Hello and welcome to AC's webinar on Novation. My name is Wendy Lespican and I'm the Director of Compliance and HR at the ACE. I'm delighted to introduce our two presenters for this afternoon's webinar, Nadir Hasan of Beale Co.
Hello.
And Henry Pipe of Max Fordham LLP.
Hello.
We anticipate that we will have about 40 minutes of presentation this afternoon, followed by questions and answers. Please do submit your questions throughout the presentation as soon as you think of them, and we will answer as many as we can when the presentation is finished. We want an interactive session today, so please do join in by sending in your questions. You will see instructions on the screen in front of you showing you how to submit questions. Please send your questions to us by choosing the Send Privately option. If we don't have time to answer all your questions today, we will ask our presenters to provide answers which we will circulate after the presentation. We will also circulate a copy of the webinar and of AC's Good Practice Guide on Novation.
Thank you, Wendy. This is the second in this series of webinars. If you missed our first webinar, which was an overview of professional appointment contracts, a recording is available on the ACE's website, along with the first Good Practice Guide. Today, we've chosen to focus on novation.
Novation is an important issue for our clients and an area that is often misunderstood. Novation can significantly increase a consultant's liability, and we're seeing more issues and disputes arising out of novation.
We should probably start by explaining what novation actually is. From the consultant's point of view, novation involves one party to a contract being replaced by another party. It is usually the consultant's client who is replaced, so in effect, novation is the process by which the consultant's client changes. But there's a bit more to it than that. Nadir, can you explain what's going on from a lawyer's point of view?
To understand how novation works, we first need to understand a concept called assignment. Under every contract, each party typically has various rights, such as the right to receive payment, and various obligations, such as an obligation to provide certain services. Unless a contract expressly prohibits it, rights can be freely assigned or given away to a third party. Once rights are assigned, the party to whom the right is assigned will receive the benefit of those rights in place of the party who received those rights before assignment. For example, unless the contract prohibits it, the consultant could assign their right to receive payment. Perhaps they assign this to their bank for security or to a debt collection agency to collect a debt. Once this right is assigned, the bank or debt collection agency will be entitled to enforce the rights as to payment in that appointment directly. Unless the contract says so, you do not need the other party's consent to assign a benefit or a right. Importantly, though, obligations cannot be assigned. So in this example, although the consultant could assign the benefit of receiving payment, the consultant would not be able to assign the obligation to make payment. Such a change could only be done with the consultant's consent. Novation goes a step further than assignment. Novation transfers both the rights and obligations of a party under a contract to a third party. And because the obligations cannot just be given away without consent, novation requires the agreement of all three of the parties.
We see this most often where someone commissioning a project appoints a design team to produce initial designs, and then appoints a design and build contractor to complete the design and construct the project. Quite often the contractor will want to maintain continuity of the design team, and so their appointments are novated, and the contractor replaces the person commissioning the project as the design team's client. So the consultant will be employed by an employer to carry out sufficient design work for them to appoint a contractor, and will then be employed by the contractor themselves to develop this through to construction. There are other circumstances where novation can take place, such as a business sale, a restructure, or a client setting up a subsidiary body through which to deliver their project. But in our examples today, we're going to concentrate on the design and build scenario. Just a note on terminology first. It's quite common to talk about the client, meaning the person commissioning the project, regardless of the contractual relationship to them. Given that novation is all about the substitution of one party for another as the consultant's client, this can get confusing. So today we'll tend to refer to the initial client, the person commissioning the project, as the employer, as this is the terminology used in many novation agreements. Nadir, people often talk about two types of novation. Can you explain these?
There are two main approaches to novation in the design and build context: switch novation and ab initio novation. The difference is to do with the identity of the client prior to novation. First, let's consider a switch novation. In this scenario, the consultant's appointment transfers from the client to the contractor at the date of the novation. I repeat, at the date of the novation. This is what happens in reality. Prior to the transfer, the consultant provides work for the client, and after the transfer, the consultant works for the contractor. There is a switch at the date of the novation from the professional appointment to the novated appointment, and a clear line in the sand. In an ab initio novation, on the other hand, the transfer of the consultant's appointment to the contractor takes place as if the consultant had always been appointed by the contractor from the outset, when the consultant was first appointed to provide design services to the employer. This is a clear fiction, as when the consultant was first appointed in connection with the project, it owed its duty to the employer and not to the contractor. It may not even have known the identity of the contractor at that time. It's important to note that a novation agreement may not use the terms switch or ab initio. The effect of the novation will depend on the particular drafting used.
So the main difference between switch and ab initio relates to the identity of the client prior to novation. A switch novation recognises that work done up to novation was carried out for the employer, while an ab initio novation makes a retroactive change so that work done up to novation was actually done for the contractor. So why is this an issue for consultants?
Whatever the novation agreement says, the reality is that prior to novation, the consultant was working in the interests of the employer. Importantly, he or she was not employed by the contractor to advise as to its tender price or similar issues. In fact, if the consultant had acted in this manner, it would have been in conflict with its duties to the employer. Because of this fiction that the consultant has worked for the contractor from the outset, ab initio novation can require the consultant to tread a very fine line in order to balance the potentially competing interests of employer and contractor. In practice, this is likely to be difficult to achieve, particularly at the outset when the consultant is working closely with the employer, often well before a contractor has been identified.
So does that mean that consultants should avoid ab initio novation and always opt for the switch style?
That has historically been the advice of consultants, but it's not that simple. Some of the problems of the ab initio novation can be overcome with careful drafting. And depending on the terms of the novation agreement, even a switch form of novation may expose a consultant to additional risks and may, in practice, have much the same effect as an ab initio novation. Ultimately, the issue for consultants is what they're liable for in respect of services performed prior to the actual novation and to whom this liability is owed. If the specific terms of the novation mean that the basis on which work has already been carried out has changed, then that is going to give rise to problems. Consultants should make sure that the contractor cannot bring a claim against the consultant for work which was already carried out, because that work benefited the consultant's then client rather than the contractor.
Earlier, Nadir mentioned a conflict of interests created by some forms of novation, and that is a key issue arising out of novation. It's quite common to hear clients, or more often their lawyers, say that everyone's interests are aligned and there can be no conflict if the consultant has complied with their obligations under the contract. But that is just not true. An employer with aspirations for their building, which they are going to be using and maintaining every day, cannot be said to have the same set of interests as a contractor who has committed to delivery of the project to a deadline for a fixed price and on a low margin. The reality is that judgments and decisions made early on in a project in the interests of the client at the time may well not be in the best interests of the contractor who retrospectively became the client.
In a moment, we look at how to avoid these issues through careful drafting. But even if the novation agreement is written in a way that the consultant's obligations aren't changed after they've already been performed, once novation has happened, the consultant still has to put the interests of the contractor ahead of its original client. And this can be difficult where long-standing relationships are involved.
That's right, and this is sometimes a surprise to clients. I've known of clients who have actively encouraged their design team to be novated across because the client wants people on the contractor's team who are on their side and are still looking out for the client's interests. This is a misunderstanding of how novation changes the obligations of the consultant, and it can have serious consequences. At best, you risk damaging a relationship with the client who doesn't fully understand that you are now employed by and looking after the interests of the contractor they wanted you to keep an eye on. At worst, you can find yourself in the middle of a very messy claim. I know of one design consultant who had a long-standing repeat client who novated them to a contractor. The design consultant and original client kept in touch after novation. The consultant kept their original client informed of what the contractor was up to, and they carried on taking instruction from them without the contractor, now their new client, knowing what was going on. This resulted in design changes which the contractor hadn't priced for, and so the contractor brought a claim against the employer for additional costs. The design consultant, who had effectively been serving two masters with conflicting interests at the same time, was caught up right in the middle of it.
What do consultants do to manage these relationships?
It's always best to avoid surprises, so I would always recommend having an open conversation with your client about the implications of novation right at the outset of the project. This is especially important if you have an ongoing relationship with them that you want to maintain. You can remind them that novation means that you will have to take instruction from and work in the interests of the contractor, and that the contractor's interests may not be the same as theirs. Then, when novation is about to happen, it can also be good practice to write to them to remind them that the relationship is about to change. Of course, before novation has taken place, you still have a duty to give the employer professional advice, and in some cases it may be appropriate to advise them that they consider retaining some advice after novation. Conventional wisdom is that contractors need the benefit of continuity of the design team, so they don't have to revalidate the whole design from square one. But a cynic might say that employing the team that wrote the employer's requirements puts the contractor in a stronger position to find all the wiggle room and loopholes. The employer will want to make sure that any changes the contractor's team make to the design strategy are still consistent with the employer's requirements, and so they may still need some specialist advice themselves after novation. So there is also an argument that the employer benefits from having the continuity of the design team. Sometimes clients will ask the consultant to undertake both roles. This can be referred to as retained services, and we'll discuss the implications of this later. But that's why we would recommend having an open conversation with your client at the outset of the project. And it may be that in some cases, they decide that novation of the design team is not the right approach, as it's more important to them that they retain the design team client side.
It's worth noting that the above might give rise to potential or ultimately an actual conflict of interest. This is likely to be explicitly prohibited by the terms of your appointment and, in many professions, such as law, would be prohibited by professional codes of conduct.
Let's turn to some of the contractual issues now. Where should a consultant start when it comes to novation and the terms of their contract?
Where novation is planned, there will usually be an obligation in the consultant's main appointment for them to execute a deed of novation on request from their client. If an obligation to novate is not agreed at the outset and incorporated in the consultant's appointment, the consultant is under no legal obligation to agree to novation at a later stage. If a request to novate is made, it would be a commercial matter to be considered in light of the particular circumstances at the time of the request. But if an obligation to be novated is written into the appointment, it is likely that the terms on which novation will take place will also be included, whether in a draft form of appointment or otherwise. So it's important to consider the surrounding circumstances to ensure that the risks are understood at the outset and are mitigated if possible. It will be too late to make these changes when novation is actually due to take place.
Now, at this early stage of the project, the identity of the person you are going to be novated to will often not be known. Once the contractor is appointed, you might find out it is a company you've struggled to get payment from in the past, or it may give rise to a conflict of interests in respect of other projects. Is there anything the consultant can do to protect themselves against this?
There are a few steps consultants can take to guard against such risks. For example, they could insist on the appointment providing that any novation is subject to their consent, perhaps not to be unreasonably withheld. However, this may well not be accepted by the client. As an alternative, they could request the inclusion of a right to make reasonable objection to a novation, which should capture such issues.
So what about the novation agreement itself? What should we look for in that?
Novation usually involves a three-party novation agreement between the two original parties, the employer and the consultant, and the third party, the new client, to whom the rights and obligations are to be transferred. In theory, all the novation agreement should do is to release the employer and the consultant from their respective future obligations to each other, and to create new obligations between the consultant and the contractor on the same terms as the original appointment. But often, novation agreements may seek to introduce variations to the underlying appointment. For example, in relation to the basis on which the consultant would be paid, the scope of services to be provided, or by introducing additional obligations. Of course, some changes might be necessary, for instance, to ensure that services you're performing post-novation are appropriate for an appointment to a contractor rather than an employer. Such provisions will need to be considered on a case-by-case basis to determine whether they're acceptable, and if so, whether additional fees should be charged. A typical approach is to reject any variations to the underlying appointment, as this contains the party's main obligations and liabilities and governs relations between the client and the consultant.
We said before that a significant issue for consultants with novation was what the consultant is liable for in respect of services already performed prior to the actual novation, and to whom this liability is owed. Let's have a look at how this liability is dealt with in novation agreements.
The consultant should ensure that whoever is able to bring a claim for services done prior to novation, whether it's the employer or the contractor, that the basis of the claim should be that the consultant was working in the employer's interests. The reason for this is, of course, that employers and contractors can and often do have very different interests on a project, and we'll see some examples of this further on. If the novation is ab initio, this can be done by including a clause which makes clear that prior to novation, the consultant was acting only in the interests of the employer and was taking instruction only from the employer. This will mean that the contractor can only bring a claim if they can show that the consultant breached their duty to their client at the time. An example is shown on the slide. As you'll see, this clause provides an explicit recognition given by each of the three parties to the novation agreement, the employer, the contractor, and the consultant, as to the situation that actually existed when the consultant commenced its work, i.e. that it was employed by the employer, and that in performing its appointment, it acted on the employer's instructions and in the employer's interest. We've shown this clause in green as it's a sort of clause you may consider including in your novation agreement. Later on, we'll show some clauses in red which you might consider removing from the agreement.
Does the consultant who has been novated still benefit from any limit of liability in the main appointment?
Assuming the deed of novation doesn't vary this clause, then any limits on liability will still apply. But it's quite common for novation agreements to extend the consultant's liability in other ways. Where possible, it's helpful for a novation agreement to contain a clause granting the consultant the right to rely upon any limitation in the appointment, including any limit of liability, and to raise the equivalent right to defence against the contractor as it would have against a client. This is particularly relevant in relation to pre-novation services. Such a clause will reduce the risk of the novation increasing the consultant's liability, as it should ensure that any claim by the contractor is subject to the same limitations of liability and defences as the claim by the client. Any drafting which tries to restrict these rights should be resisted. A common way of providing the contractor with the right of recourse against the consultant is to include a warranty in favour of the contractor that the pre-novation services undertaken by the consultant have been performed in accordance with the terms of the appointment. As we mentioned earlier, ideally this would reflect the obligation to act for the employer at this stage, so that if the consultant is in breach of the duties owed to the employer, the contractor, who is after novation the consultant's new client, may sue the consultant to recover any loss suffered as a result. The clause on the slide provides a warranty to the contractor in respect of the consultant's performance of its services before the date of the novation agreement. This permits the contractor to rely on these services and to claim against the consultant in the event of any issues with them. However, crucially, from the consultant's perspective, and as with the clause in the previous slide, it recognises that these services were performed for the employer. However, the warranty will often go further and warrant the consultant's performance under the appointment generally, or as though the consultant had always owed its obligations to the contractor. This can significantly extend the consultant's liability. The clause in red here, in contrast to the one in green, states that the consultant has performed and will perform its services in favour of the contractor. This is clearly not what will have happened in reality. But the clause then goes further to say that this will be deemed to have been the case as if the contractor was and always had been a party to it in place of the employer. Again, this is a fiction and could be problematic for the consultant if the contractor does bring a claim relating to services performed before the novation. Many novation agreements include drafting to the effect that the consultant acknowledges that the contractor, in performing its duties under the building contract, has relied on advice and information provided by the consultant to the client under the appointment, similar to the clause shown on the slide. This can create an additional obligation to the contractor in respect of work done for the employer. It can also make it easier for the contractor to bring a claim without having to show that the consultant's breach caused their loss, and it can reduce the consultant's ability to mitigate a claim by pointing to the contractor's contributory negligence. So we recommend that clauses like this are deleted, leaving the contractor to prove their reliance in any claim. And it's important to note that these clauses can appear in switch or in ab initio novations.
Sometimes we see clauses that say something like particular losses were within the consultant's contemplation. What's the effect of this sort of clause?
These are used to prevent arguments that the contractor's losses are too remote and therefore not recoverable. For example, claims for loss of profit or perhaps liquidated damages imposed on the contractor, which would, of course, not have been incurred by the consultant's original client, the employer. So novation agreements often include an acknowledgement by the consultant that any losses suffered by the contractor arising out of information and advice provided by the consultant to the client in the performance of its duties under the appointment pre-novation were within the contemplation of the consultant at the date the appointment was entered into. There's a standard clause for this on the slide. This does not reflect the reality, particularly given the consultant may have no idea who the contractor will be when it's carrying out its services pre-novation. Such provisions further extend the consultant's liability beyond those matters for which it would be liable to the original client. If possible, such provisions should be deleted, leaving the contractor to claim its losses in accordance with the usual principles of recovery. And again, such clauses may appear in switch novation as well as ab initio novation. A similar issue is the so-called no loss argument. There's a case that's often quoted between Blythe and Blythe and Carillion. Before novation, Blythe and Blythe produced the employee's requirements for their then client, but in doing so, they significantly underestimated the amount of steel reinforcement that would be needed. Carillion priced and entered into a fixed price contract on this basis. Blythe and Blythe were subsequently novated to Carillion, who then claimed against them when the error came to light and they realised the additional costs they would have to incur for the extra steel reinforcement needed. However, the court found that Blythe and Blythe were working in the interests of their client at the time and not of Carillion. And the employer ended up getting a better deal because the error worked in their favour, so they incurred no loss. The way that this particular novation agreement was interpreted, Carillion could only claim for losses resulting from pre-novation work which the original employer would have incurred. This case also underlines how employers and contractors' interests can differ on a project and why it's so important for these differences to be recognised in contractual documentation. In response to this case, novation agreements often include provisions which prevent a consultant from arguing in defence of any claim by the contractor that he or she should not be liable because the employer would not have suffered this loss. An example of this sort of clause is on the slide. This provision makes the consultant liable for losses suffered by the contractor as a result of the consultant's breach of the appointment prior to novation, even if those losses would not have been suffered by the client. So even if the form of novation is not ab initio, the consultant is still required to walk a tightrope prior to novation so as to avoid liability to either party. It's in the consultant's interest for this provision to be deleted, although I would point out this is a very common provision which the contractor is likely to insist upon.
Ultimately, clauses like this will be a commercial decision. You could argue that the contractor ought to be pricing for this sort of risk, but where, as in this case, the contractor's losses were a direct result of the consultant's breach of its obligations to its client at the time, it could be difficult to argue as a consultant that you should have no liability at all. Are there other ways that the consultant can acquire greater liability?
Novation agreements may introduce an obligation on the consultant to ensure that the building contract, by which the contractor is appointed to the employer, or the programme is complied with. Such an obligation could increase the consultant's duty of care, and it may amount to a fitness for purpose warranty, depending on the provisions of the building contract, or a strict obligation, for example, in relation to any programme requirements. Where possible, such additional obligations should be deleted or qualified by reference to the duty of care required under the consultant's appointment, and any implied or express fitness for purpose warranty should be resisted. In any event, copies of the building contract, programme and other relevant documents should be provided to the consultant prior to novation to ensure the risks can be assessed in advance. The novation agreement may introduce an indemnity in favour of the contractor or of the employer. Such indemnities can greatly increase the consultant's liabilities, as in addition to being liable to the contractor in respect of pre-novation losses, they can result in much greater recovery than would otherwise be possible in a normal claim for damages. As a general rule, indemnity should be resisted wherever possible, not just in relation to novation. Where the provisions cannot be deleted, they should be qualified, such that the beneficiary of the indemnity has a duty to mitigate its losses and is only entitled to recover its reasonable and proven costs resulting from the consultant's negligence. There is more information about indemnities and about liability more generally in the earlier webinar, which Henry mentioned.
Thank you, Nadir. That's been a really useful explanation of some of the liability issues. There are some other practical issues that we should talk about too, and I think the first is payment. Novation agreements very often include statements that say all payments due up to the date of the novation appointment have been paid. If you sign this and it's not actually true, you could find that you lose your right to claim for payment of outstanding fees. This is because you are releasing the employer from their obligations to pay you, but the contractor's obligations won't go back to fees which you have stated have already been paid, even if that statement is not true. So you should only ever sign up to this clause if it is actually true. Otherwise, you might want to include a provision which makes clear that all sums arising before or after the date of novation will be paid by the contractor, or making clear that the employer is not released from their obligation to pay fees which were due prior to novation. However, you should be aware that the statement should be true on the date that the novation agreement takes effect, and that is not necessarily the date you sign it. Often this is done by solicitors representing one of the parties once all parties have signed and returned the contracts. So you might consider including a schedule of fees billed and paid and only issue this on the day that the novation agreement is due to be put into force. Or you can agree with the solicitors that completion will only happen on confirmation that payment is up to date.
We said earlier that the consultant's appointment will usually require them to be novated and specify the form of novation. Sometimes appointments are silent as to the form of agreement or simply refer to an appointment in a form acceptable to the employer. Such provisions should be avoided if possible, or qualified to give the consultant a right to refuse or to propose its own form of novation agreement. You'll have seen from the issues we've discussed today that novation can be a bit of a minefield, and it's incredibly important to get the novation agreement right. The CIC have published a standard form of novation which the ACE, along with various other industry bodies, endorses. It's the 2004 version and it's a switch form, and we would always recommend using this form if possible. We understand that the CIC will shortly be releasing a new edition of this switch type form of novation, along with an ab initio form of novation for the first time. Once these are published, bodies like the ACE will review them and will update their members on whether they recommend their use.
For consultants in the construction industry, it's very common for us to start work while our agreement is still being negotiated. I'm sure we all know of projects where the contract isn't signed until the very end, or sometimes never at all. There are risks to this. The consultant's liability will be unlimited if there is no contract, and the fees and services will still be open to revision. But ultimately, you can usually find a mechanism to secure payment for services, and the common law and legislation provides a basic legal framework for you to operate in. But things are quite different when we're dealing with novation. If you act as if you are novated before there is a novation agreement in place, then you can find that you're taking on new liabilities to the contractor by working for them, but you won't have terminated your obligations to your original client, and so may well be breaching your duty to them. It's not uncommon for everyone to act as if novation has happened without the novation agreement in place. The contractor requires the consultant to do work, and the consultant takes instruction from them. But then things go wrong. I've seen contractors and employers both say they have no obligation to pay the consultant, and I've seen consultants get caught up in claims between the contractor and employer who can't agree between them which one the consultant is required to support. So if ever there is a situation where it's worth your while standing firm and not carrying out work without a signed agreement in place, it's when you're being novated. Now, we mentioned earlier that retained services can give rise to a conflict. So let's talk about that for a moment.
On occasion, consultants may be engaged by their clients at the outset of a project to carry out project administration or monitoring roles in addition to their design obligations. Where this is the case, the employer will often require the consultant to continue to provide to it the project administration and monitoring services after novation. In addition, the consultant will, of course, be providing design services to the contractor. Another scenario is that the consultant is employed to comment to the employer on the performance of the contractor during the later design and site phases, while separately also working for the contractor. I have to say, this is becoming increasingly common. This gives rise to a number of practical issues. The main issue is the real prospect of a conflict between the consultant and its obligations to the contractor under the novated agreement and its ongoing administration or monitoring role to the employer. For example, under a monitoring role, the consultant may have to assist the employer in any dispute with the contractor. Moreover, there may be a scenario where the consultant is instructed by the contractor to vary its design, which the consultant knows will put the contractor in breach of the building contract, and in turn the consultant must notify the breach to the client under its monitoring role. There are a number of approaches to deal with retained services within novation documents. The cleanest approach would be to have two separate appointments at novation, one for the novated design services with the contractor and one for the retained services with the client, with appropriate conflict of interest and confidentiality drafting. However, this often attracts some pushback from clients, although we know some consultants who have successfully negotiated this. More typically, the obligation to carry out such retained functions may be included in the novation agreement or in any collateral warranty agreement between the consultant and the client. The latter is perhaps the most common. In relation to the potential for conflicts of interest, these can be mitigated by the use of Chinese walls within the consultant organisation and/or the use of dedicated staff or teams to carry out the retained functions. In any event, it's important that the retained functions are clearly defined and separated from the functions which are to be novated in both the original appointment and then in the novation documentation.
Now, those are effective strategies to mitigate the legal risk, but even with sound appointments and Chinese walls in place, it's difficult to get over the obvious commercial problem that if there is an issue between the contractor and the employer, you may well find yourself having to support both sides separately. And if the two parties are reliant on your firm as their professional advisor, you're effectively in dispute with yourself, and that with all the additional costs and the time that you will incur by being on both sides. And that brings us to the final thing we'd like to cover today before we turn to your questions, and that is collateral warranties.
A collateral warranty is an agreement direct with a third party which allows them to bring a claim against you directly if you breach your duties to your client. They're often requested by project funders, purchasers and tenants, but in the context of novation, they're often used to allow the employer to continue to be able to bring a claim against you directly after they've transferred their right to do so under the appointment to the contractor. So in effect, the consultant may be liable to both the client and the contractor in respect of the same breach. Collateral warranties generate an additional cause of action and so increase the consultant's risk. It's ultimately a commercial decision for the consultant whether to agree to give warranties, but consultants may want to price this risk. As with the novation agreements, the obligation to grant a warranty should be made clear in the original appointment, and the terms of the warranty should be set out and agreed then. We don't have the time to go into warranties in too much detail today, but the key things to look out for are to make sure that the warranty is clear, that it doesn't place the consultant under any greater liability than under its appointment, and that the consultant can still rely on any limitations or defences available under its appointment. And as with Novation, standard forms are available from the CIC, and we would recommend that you consider using those wherever possible.
That's given an overview of just some of the issues that arise for consultants with Novation. There's more information in the ACE's Good Practice Guide, which we will circulate. This is part of a series of guides, so keep an eye out for additional ones coming out over the following months. And if there are areas you'd like the ACE to cover, do let us know. The ACE also provides a telephone advice line for free advice on general issues, and the details are included in the slides. If you have questions on a specific appointment, you can get legal advice from Nadir's firm or another lawyer familiar with consultants' contracts in the construction industry. Many insurance brokers, including all of the brokers on the ACE panel, will also provide a contract review service too. But do check with your broker whether they are just confirming that the contract is covered by your insurance or whether they are commenting on other commercial issues. That brings us on to your questions. There have been several submitted during the webinar. We'll try to get through as many of them as we can, and we'll circulate responses to the rest along with the slides. But let's start with a question that we've got here. It's about novation taking place by notice. The questioner says, I often hear employers say that novation can take place by notice and that our consent is not required. Is this correct?
Not quite. This is the case for assignment, which, as we've said, deals with giving away a party's rights. Unless assignment is explicitly restricted in the appointment, for example, by requiring that the consultant's prior written notice be given, the employer can assign its rights by notice. However, this is not the case for novation, which deals with transfer of a party's obligations. Employers do sometimes say in negotiation that obligations can be transferred or that an appointment can be novated by notice. But from a strict legal standpoint, this isn't the case, and the consent of all parties will be required. Usually, as we've said, this consent will be given in a novation agreement.
There's a similar question that's come in that maybe Nadir you can respond to as well. We sometimes see drafting appointing the client as the consultant's attorney for signing a novation agreement. Can we accept this?
The short answer is no, you shouldn't. Usually, an appointment will have a form of novation agreement annexed to it, as we've said, and a contractual obligation to enter into that form of novation if requested by the client, for example, within 5 days of the employer's request. If this is the case, then once your employer requests that you novate the appointment, you've got a contractual obligation to enter into that form of novation agreement. If you don't do so, then the employer will usually have to sue you for specific performance. In other words, it'll have to go to court and seek an order obligating you to enter into the agreement. This can be a time-consuming process. However, if you appoint your employer as your attorney, then he can simply enter into the novation agreement on your behalf. You will be bound by it, and this is the case even if you haven't seen the final version of the novation agreement and you don't know its terms, or if those terms are different from the terms that you'd agreed previously with the employer. The new client, the D&B contractor, will be able to enforce this novated appointment against you, and your only remedies, if any, will lie against your employer. It's worth pointing out there's a similar issue with providing your employer with a pre-signed novation agreement, as is sometimes requested. In this case, you can at least be sure of the terms of the agreement, but you'll still have no control over when you're novated, or if, as is sometimes requested, if you leave the new client's name blank, who you're novated to. For example, you could be novated to a contractor in financial distress.
There's a question here to do with fees. Part of any initial fee for a project is allocated to the cost of negotiating and agreeing contract documents. If a project is subsequently novated, the contract will have to be renegotiated and agreed with the new company. Should we be charging an additional fee for this process? That's a very interesting question, actually, I think, Nadir. I mean, it recognises that there is additional administration that comes with Novation, and I think it's not just the Novation agreement itself, but also the warranties that you end up having to sign that can be quite time consuming. But it's also worth noting that every agreement you sign has the potential to extend your liability, even if the agreement is drafted in a way that you can rely on the same limitations. You've still got additional parties who can bring a claim, so that opens up the scope for being in a situation where you're defending a claim. So I think there are very real additional administrative costs and very real additional risks that you are taking on if you're being novated, and I think it's always worth making sure that your fee reflects that. As for whether you can charge a particular supplement to negotiate a novation fee, I think that's something we would all like to do, but I think there's a commercial reality to that, and you may struggle to get it agreed. But certainly novation is something you should completely take account of when setting your fees. Now there's another question about working with the original client after novation. The questioner says, from what you've said, this seems like a risk. To what extent do we still owe duties to the original client following novation? I think it is essential to remember that once novation has taken place, you will owe your duties primarily, if not completely, to your new client rather than the original employer, and you will always have to act accordingly. But you will continue to be part of the design team after novation, and you'll be required to cooperate with all of the other parties, and that will probably include the employer. And this will be specifically required by the terms of your employment, of your appointment. However, you must always act in the interests of your new client. So if, for example, the original client asks you to report on the performance of the contractor, be very cautious. Note also that any confidentiality provisions in the appointment, so for example, another consultant, say one who's not been novated and is still working for the employer, asks you for information, you'll need to check very carefully whether you're permitted to provide this. Always keep at the back of your mind that your original employer's interests may well not be the same as your new client's interests, and that it is your new client that you now act for. And I think the Blythe and Blythe case that we mentioned earlier provides a very good example about why this is. One last question we've got, can a novation agreement extend or change the scope of the original works by changing or removing assumptions and exclusions from the original appointment document? Nadir, is that one you'd like to comment on?
Absolutely, and I'm afraid I'm going to give a typical lawyer's answer and say it depends on the drafting. The short answer is yes, absolutely, and this is something to watch out for very carefully, because as we've said, any novation agreement can amend the substantive terms of the original appointment document. And it can do so by varying its legal provisions, but it can also do so by amending the commercial elements, and this could be it could be assumptions, it could be exclusions, absolutely, but it could equally be scope of works, for example, and this is something to look out for very carefully, because the contractor may have very different interests from those of your original client.
There's another couple of questions just come in that I think we've got time to respond to. Someone has asked, is there a positive side to novation? I think we've perhaps been a bit down on novation and a bit negative about it. I mean, certainly there are additional risks for the consultant, and I think from the consultant's point of view, a lot of risks come from the fact that the way in which they're working and the person they have been working for has changed. So during the course of the project, something has changed and is different from how they anticipated the project at the outset. But I think there's a commercial reality to design and build projects, that there are particular sectors where the majority of the work will be procured on this basis. And so if you want to be involved in that sort of project, I think novation is the reality that we're living with. And so in many cases, if you are particularly interested in being involved in the later design stages of the project and being involved in doing the design rather than just checking what someone else has done, then novation is probably going to be the route that allows you to do that. I think one final question, I think this is for you, Nadir. Is it right that novation agreements can give rise to a separate cause of action, separate from the appointment itself?
Generally speaking, what a properly drafted novation agreement will do is change the identity of the party that has the right to bring an action against you in respect to the services that you've performed under the appointment. Now, as we've said, there is a distinction between a switch form of novation, and under a switch form of novation, your original employer may continue to have rights against you in respect of services carried out pre-novation, and the new employer, the contractor, will do so for services carried out subsequently. Under an ab initio novation, then the switch will happen ab initio. So as at the date of the novation agreement, your old employer's rights will fall away. The new employer will assume all rights under the appointment. Under a properly drafted novation agreement, I suppose you could have a right arising for a party to bring a claim under the novation agreement if you breach any substantive terms in that. But that would be an unusual situation, and as a consultant, you would primarily be concerned with rights arising under your appointment.
So I think there the thing to be looking for is also the warranties, because the warranties are very explicitly creating a new cause of action. So I think that's perhaps something that consultants will need to keep an eye out for as well.
Absolutely, warranties in any context do give right to new causes of action, and they can very significantly extend a consultant's obligations and its liabilities. We always say that you should be very, very careful when agreeing to give warranties, and this is the case under an appointment, and it's particularly the case under a novated appointment.
I'm afraid that's all we have time for today. We'll just leave you with a slide summarising the key points we've covered. Following this webinar, we'll circulate the slides, a link to the recording, and a copy of the Novation Best Practice Guide. Thank you very much for joining us.